All right, so lawyer advertising, as probably most of you know, prior to 1977, lawyers were not even allowed to advertise. And then you had the Bates versus Arizona case, which opened up a Pandora's box of lawyer advertising. And of course, the states wanted to regulate that. And what's kind of happened is it was regulated pretty heavily in the beginning, and then many of the states have kind of backed off with some provisions. So it's a topic that's too wide to tackle in this kind of a venue. I just have a couple of thoughts. If you're thinking about lawyer advertising, here are some themes that you want to keep in mind. The first thing I would point out to you is that these regulations, the Code of Professional Conduct, is very state specific. What you can do in one state, you might not be able to do in another. The right of the lawyer to advertise has been established, as I said, since 1977. It's a First Amendment thing, so that's not anything that can be state specific, but how it's regulated is. So if you are going to advertise, you really need to consult your specific rules in your state. One of the main themes that runs through the lawyer advertising regulations is they're trying to prohibit false, deceptive, and misleading statements. Even though many of the states have kind of relaxed their regulations on lawyer advertising, that theme has never changed. So if there's anything in the advertising, whether it's tasteful or not tasteful, or your cup of tea or not your cup of tea, what the regulators are looking at is there anything that you're communicating that is deceptive, false, or would be misleading to clients? Now, separate and apart from that is the question of tasteless advertising. And you can Google lawyer advertising, and it's, some of the stuff out there is just horrendous, silly, ridiculous, and some states tried to regulate that. My state did that. New York did that. There was some regulations that was really kind of targeted at some of these mostly personal injury lawyers that just had commercials that were, I don't know, demeaning to the profession. They weren't false or misleading. They were advertising their services, but in a very distasteful way. And New York had regulations that tried to prohibit that. There was a major personal injury law firm in my area that sued them, and they won. And so the regulations had to be reworked. So now, if it's silly or tasteless, as long as it's not misleading or deceptive in any way, it's going to meet the muster. So here's some things that you can do in lawyer advertising. I'm using New York as an example now. So remember, in your state, it may not be the same. They're all based on the model rules, but they may change between state. In New York, you can actually talk about expectation of results. As long as you're not misleading the potential client, you may say, we've settled, 100 personal injury cases, and the average award is such and such. As long as that's true, and you can back that up, you can do that. You can have testimonials. You can have clients come on and talk about their case and how they were treated, and you're very happy with the result, that kind of thing. If they're being paid, you have to disclose that they're being paid. If they're actors portraying it, you have to say that it's an actor portrayal based on a real case. You can actually characterize the quality of your services in a way that is not subject to any kind of validation. Like what you can't do is, we're the best lawyers in the city, or we get the best results. I mean, there's no way that you can substantiate that. That you can't do, but you could do things that would say that, would speak to the quality of your services. In New York, you can even compare your services to other lawyers. For example, there's a large personal injury law firm in New York, mainly in upstate New York, that does nothing but car accidents. And they can say, other personal injury law firms that do a variety of personal injury services, we only handle car accidents. That's true. So it's not violating the rule, but it is comparing their services. So whatever you're doing in terms of, talking about the quality of the services or comparing your services to other lawyers, you have to be able to factually support it. And in New York, for example, you have to have a statement. If you do that, if you're talking about, prior cases where you got a certain amount of awards, etc., the language is prior results do not guarantee a similar outcome. So you're prefacing that, yes, we did get these, that's true, that doesn't mean that you're going to get this kind of a reward. What you can't say, as I said before, is, we're the best, we're the most experienced, that kind of language which nobody could actually prove or not prove. One of the examples in the commentary, which I thought was interesting to the rule, was the statement, "I've never lost a case." Now, that might be true. Maybe you never lost a case. But what if that lawyer never tried a case? What if all the cases were settled? So, never lost a case, technically true, but the presumption is that he's tried cases and never lost, which is untrue. So again, we're back to false, misleading, or deceptive statements. So those are some of the things you should keep in mind if you're considering advertising your services.